Hi everyone and welcome back to another video. The asylum seeker whose arrest and charge for sexual assault against a child, which sparked weeks of protests outside of a hotel in Epping, which was housing asylum seekers, has been jailed for 12 months after being found guilty following a trial at Chelmsford Crown Court. Now in this video I'm going to go through the district judge's sentencing remarks and explain how they came to the sentence that they did. Welcome to my channel, Andy on Crime, where I talk about high profile criminal cases and other aspects of criminal law in England and Wales. And if you would like to support my channel, then you can click the link in the description and sign up with NordVPN, where you can get a huge discount on a range of their plans. With all that being said, let's get into the video. So before I go into the sentencing remarks of the district judge, I'm just going to briefly cover the facts of this case. On the 7th of July of this year, Hadush Geberslasie Kebatu, who is an asylum seeker from Ethiopia and who arrived in the country on a small boat, was being accommodated at the Bell Hotel in Epping. On that date, he attempted to kiss a 14-year-old teenage girl on a bench whilst also asking her to kiss him. He also made numerous sexually explicit comments towards her. The following afternoon, on the 8th of July 2025, Kebatu encountered the same female girl that he had tried to kiss the previous day and sexually assaulted her by touching her thigh. He also made further sexually explicit comments towards her, despite being told of the girl's age of 14 and the fact that she was wearing a school uniform. In addition, he told the girl, who was with a male friend, to kiss that male friend, which she did in the hope that if the defendant thought that the boy was her boyfriend, that Kebatu would leave them alone. Instead, this made Kebatu aroused. Shortly before this interaction, Kebatu had sexually assaulted and attempted to kiss an adult woman who had offered to help him with his CV in order to find work. When she saw that Kebatu was interacting inappropriately with that teenage girl, she called 999 and he was arrested shortly thereafter. He was charged with 5 offences: attempted sexual assault on a child aged 14 on the 7th of July 2025, and the remaining offences on the 8th of July 2025 of inciting or causing a child aged 13 to 15 to engage in sexual activity, sexual assault on a female aged 14, harassment without violence, and assault on a female, that being the adult. Kebatu denied these offences and stood trial at Chelmsford Crown Court, but was found guilty by the district judge. He was then sentenced to 12 months imprisonment. So I'm now going to cover the judge's sentencing remarks so I can explain how the judge came to the decision that they did in terms of this sentence. Hopefully you'll see some of the remarks appearing on screen, and I've put a link in the description as well to the full sentencing remarks if you want to read them, and I would encourage you to do so. So the judge covers each of the offences in order, so deals with the first offence on the 7th of July, which was the attempted sexual assault. Now when it comes to sentences, and this is a general application, sentences are generally determined by the Sentencing Council, who provide sentencing guidelines which judges must follow unless there's good reason not to, and even if they do decide not to, they can often be subject of appeal. Sentences are generally determined by 2 factors: culpability and harm. So the more culpable a person is for their actions and the more harm that's caused, the higher the category that that offence is placed into. So in respect of this offence, the judge was required to look at the sexual assault guidelines to place this into a category, being mindful, of course, that this was an attempt rather than an act, and the law treats an attempt slightly less serious, albeit not downplaying the actions of the defendant or the impact on the victim, but they are treated slightly less severe than if the act had been carried out itself. And in respect of harm, there are 3 categories of harm, and you can hopefully see them at paragraph 15 on the screen. Now, the judge determined that categories 1 and 2 were not present here. The one factor that the judge thought long and hard on is whether the victim was particularly vulnerable due to personal circumstances. But you can see at paragraph 17 that there is case law which states that just because a person is aged 14, that does not amount of itself to be vulnerable. It could be an important factor towards it. But the judge concludes that because the complainant, the victim in this case, was with friends in an open public space, they did not determine that that factor was met. Therefore, the default is if it doesn't meet category 1 or 2, it will go into category 3. The judge then also considered the culpability of the defendant. And you can see all the factors there at paragraph 19 in respect of things like abuse of trust, recording the offence, etc., etc. If those factors are not present, then again it drops into the other category, which is culpability B. And the judge determines here that the factors in culpability A are not present, therefore the offence becomes one of a 3B offence. That then translates to a grid, and I'll hopefully put the sentencing remarks grid up on screen so you can see the range across the various categories. But the starting point for a category 3B offence is a high-level community order with a range from a medium-level community order to 26 weeks in custody. And as I mentioned, this difference between an attempt and an actual act itself, at paragraph 24, the judge makes reference to that. The judge also, when they determine the starting point, then adjusts the sentence up or down depending on aggravating or mitigating factors. The judge found that the age of the victim, which had not been counted earlier in terms of harm or culpability, the victim was 14 here. The mitigating factor here was that the defendant had no previous convictions, which is considered a mitigating factor in these cases. So turning now to the offences on the 8th of July 2025, the judge firstly deals with the sexual assault on the 14-year-old girl and the offence of inciting or causing a child to engage in sexual activity. The judge firstly deals with the sexual assault, which he concludes that was the most serious of the 5 offences before the court. Now, I've shown you the factors which might push something into higher levels of culpability and higher levels of harm. One thing I should say is during the sentencing process, both the female victim, that was the child, the 14-year-old girl, and the adult victim both provided what are known as victim personal statements, which outline the impact that the offending had on them. And this is relevant to 2 factors. A, it explains how the impact is affecting them both ongoing and at the time, but it also helps the judge with categorisation of the offending for factors like harm. So if someone is suffering severe psychological consequences, had to go through counselling, seek medical treatment, being signed off sick from work, etc., etc., these are all factors that assist the court in determining the categorisation of harm. And of course, if the categorisation is higher, that increases the starting point for an offence. So the background to this case is that the victims would have provided victim personal statements to the court, which would have been heard. So the judge here determines that none of the factors for increased levels of harm apply here, and nor do the culpability factors. So he places it in 3B. Again, the judge considers an aggravating factor of the fact that she was a 14-year-old girl wearing her school uniform, and of course the fact that this was a repeated act against that girl given the behaviour of the defendant the day before. He takes into account the fact that, again, he has no previous convictions. With regards to the offence of incitement or causing a child to engage in sexual activity, the judge highlights the categories of offending similar to sexual assault, and I've put them on screen at paragraph 37. So category 1 involves penetration of the vagina or anus, penile penetration, or in either case of or by the victim. That's not present here. Touching or exposure of naked genitalia or naked breast by or of the victim for category 2. Again, that's not present here. And other sexual activity. So the male and the female children that kiss each other, that would be considered a category 3. Had they done any of the things in category 2 or 1, then that would have been the category it was placed in. Turning to the issue of culpability in respect of this specific charge, and again you can see at paragraph 39 the factors that might place it in culpability A. The judge determined here that the factor which is disparity or significant disparity in age was present here. The victim was aged 14 and the defendant was at least 39 years old. As a result of that, that places it in culpability A, so this is a 3A offence. And the starting point for that, and again I've hopefully put the grid up on the screen, that shows a starting point of 26 weeks custody with a range of a high-level community order up to 3 years in custody. He didn't increase the sentence or consider an aggravating factor to be her age because that was already factored in to the culpability, i.e. the fact that there was a disparity in age, has already been factored in to where this is placed in the categorisation of the offence. So it's not considered an aggravating factor because that would be double counting. The mitigating factors remain the same, that he has no previous convictions. The judge then turns to the final two offences, which were the sexual assault on the adult victim, who was essentially trying to assist the defendant in getting a job by helping him write a CV. The judge places this again as a category 3B offence because none of the factors that place it into higher levels of culpability or harm, bearing in mind that they would have heard the victim personal statement of the victim in this case. And again, I put the grid back up on the screen. The starting point is a high-level community order with a range of a medium-level community order up to 26 weeks in custody, no aggravating factors, and the mitigating factor of no previous conviction is present. The final offence is harassment towards the 14-year-old girl, which was over the course of 2 days of the 7th and 8th of July. The judge placed this into category B2, and that attracts a starting point of a medium-level community order. What the judge then does, having now established what the starting point and then adjusting for aggravating and mitigating factors, is to now consider something called totality, which I'm going to talk about in the next part of the video. So when you are sentencing for multiple offences, sentences can either run concurrently, i.e. at the same time as each other, or they can be consecutive, i.e. you finish one sentence and then you move on to the next sentence. Generally, if the offending falls out of the same behaviour, i.e. there are multiple offences arising out of the same incident, those sentences will generally run concurrently alongside each other. If they are distinct separate sentences, they generally run consecutively, so they run one after the other. So now that I've explained all of this, you're probably sat there thinking, well, what does this actually mean in terms of the sentences awarded for each charge? Well, at paragraph 63, the judge deals with the attempted sexual assault on the 7th of July. And the judge determines that the appropriate sentence for that charge is to be 4 months imprisonment. He then deals with the two offences in relation to the 14-year-old girl, the sexual assault itself, and the inciting or causing a child to engage in sexual activity, kissing the male friend that she had. And the judge determined the appropriate sentence for both of those offences was 8 months imprisonment, which were to be concurrent to each other, but consecutive to the offence on the 7th of July. So thus far, the sentence is one of 12 months in total for those three charges. The judge then goes on to talk about the sexual assault against the adult female. The judge awarded a sentence of 2 months imprisonment, but determined that it was to run concurrently, not consecutively to the other offences. The judge determines that it was of a lesser seriousness, and he reiterates the comments of the victim themselves in this case, that her concern was for the behaviour of the defendant against the 14-year-old girl. So he awarded a concurrent sentence for that sexual assault. And in respect of the harassment charge, which was an overarching charge for the behaviour of the defendant against the 14-year-old girl, the judge recorded no separate penalty, i.e. no specific penalty to be awarded for that, but the behaviour of the defendant is captured by the two sentences of charges 2 and 3, by the 8 months consecutive to charge 1 but concurrent with each other for the behaviour of the defendant towards the 14-year-old girl. So the total sentence awarded is one of 12 months imprisonment, and the judge then considered whether or not it was appropriate to suspend the sentence, because any sentence of greater than 14 days but less than 2 years is capable of being suspended. But for the reasons outlined in the judge's sentencing remarks, this was not appropriate, so an immediate custodial sentence was given. So the practical implications of this sentence are that the defendant will serve 40% of that sentence before he is released from prison. There are also some what are called ancillary orders that follow as a result of his conviction. He will be required to be on the sexual notification requirement, or the sex offenders register as people would know it, for a period of 10 years. And he was also given something called a sexual harm prevention order. So he is prohibited from things like approaching any lone female not previously associated with him, or having any contact or communication with a child under the age of 18. And that order was put in place for a period of 5 years. So to summarise, the defendant was convicted of 5 charges. 3 or 4 of those offences were against a 14-year-old girl. 1 of the offences was against an adult. He was sentenced to 4 months on the first charge, 8 months on charges 2 and 3 to run concurrently to each other but consecutively to charge 1. And he was given a 2-month sentence in relation to the sexual assault against the adult female, and no separate penalty for the overarching harassment against the 14-year-old girl. So the total sentence is 12 months imprisonment, of which he will spend 40% of the time in prison before being automatically released on licence and likely deported as a result of this. Thanks for watching. If there's any questions or comments on the case, then please do drop them down below. If you did enjoy this video, then please do give it a like. And if you'd like to see more from me, then please do subscribe to my channel. Thanks for watching. Take care.